Welcome to the Profiles in Leadership series. It offers an unparalleled opportunity to glean insights from top leaders who serve in government, education, private sector, and civil society. In each episode, we invite these leaders to reflect on their journey and share skills, core values, and qualities that make them the leaders they are today. I'm very pleased today to welcome Andrei Iancu, partner at Irell in Manila. Andrei was a former Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office, a position to which he was confirmed unanimously by the Senate. In 2021, Andrei co-founded the Renewing American Innovation Project at the Bipartisan Center for Strategic and International Studies, CSIS. In 2022, he also co-founded the Bipartisan Council for Innovation Promotion, C for IP. Welcome, Andrei.
Thank you, Daryl. Great to be with you.
And happy birthday.
Almost.
Almost.
Thank you.
Let's talk about Humira. You wrote an op-ed explaining how it shows that the patent system is working. You say the real news is that the patent system is well-balanced and working as intended. A wildly popular and effective drug was invented and brought to the market. Why did you feel a need to write that op-ed?
Well, primarily, Daryl, because I was responding to an op-ed that appeared, or a story that appeared in the pages of the New York Times, suggesting that Humira and the company making Humira, AbbVie, was somehow doing something inappropriate with the patent system because somehow Humira was so successful and it made a lot of money for its company. And that, in my view, is a wrong view of what has happened. As a matter of fact, we should be celebrating any product, including medical products, that are successful. Humira happens to be not just successful, but wildly successful because it is a great drug for patients. It's prescribed a lot. It is, in many cases, a miracle drug. It addresses various conditions and greatly helps millions of patients around the world and over time. So that should be celebrated. So now we have to think about what's the role of the patent system in that phenomenal success. And the fact of the matter is that the patent system plays a crucial role in the development of innovative technologies of all sorts, including pharmaceuticals.
Is it possible, you think, to find the right balance between encouraging innovation in vaccines and therapies and getting them out to the people that need them, not just in the United States, but around the world?
Well, for sure, but just focusing on still on Humira for a bit and other drugs like it, I think in the United States, the balance is approximately right. The fact of the matter is, take Humira, for example, it's been wildly successful and it's been on patent for about 20 years, which is the expected life of a patent. And now, as of earlier this year, in 2023, it's now off patent and it's available for generic entry into the market space and competition. That's exactly what the patent system is supposed to do. Encourage investment in risky technologies, reward those that succeed, protect them for a limited period of time. That's what the Constitution says. And then teach the public, enable competition, and follow on innovation. That is precisely what the patent system is supposed to do. And Humira is a prime example of how that has worked perfectly well. Now, you're asking, is there a further balance that's needed overseas, encourage innovation in the United States and then give access to countries overseas, to patients overseas. Again, I believe by and large, the worldwide intellectual property systems already provide that balance. There's always improvements that can be made, no question. However, we have a system where innovation is encouraged and once successful, protected and rewarded. Within the time of protection, the rule of law, the patent protections, for example, and other forms of intellectual property enable collaboration between companies, both domestic and internationally, enable the transfer of that technology pursuant to license agreements internationally. And when the patent expires, it enables competition in various other jurisdictions. Keep in mind, some jurisdictions don't have any patent protection if the patent owner didn't get them. In those jurisdictions, if there is no patent protection, then there is no further balance or no further action needed. So it's been very difficult for me to understand the criticisms that there hasn't been sufficient access worldwide, especially to vaccines. But we can talk a bit more about that if you'd like.
Well, let's talk about that. The TRIPS waiver, another issue that you have been very vocal about. Is it misinformation? Is it politics, or just plain old, we want things for free?
Well, it's a bit of all of the above. One thing it is not, the TRIPS waiver, one thing that it is not is to provide more vaccines to more people around the world. The one thing that those who advocated for the waiver, the one thing that it did not accomplish is the waiver did not accomplish the thing that they said it would, which is more access to vaccines. The fact of the matter is that IP has never stood in the way of access to vaccines. Many countries, like the United States, are swimming in vaccines. We have many more doses available than people are willing to take at this point. We can certainly, if necessary, ship them overseas, but that's not an issue of IP. That is an issue of export controls. It's been an issue of export controls from day one of the pandemic. It's an issue of transportation logistics, refrigeration logistics, and the like.
So let me ask you, does the US government understand this, what you just said?
Well, look, I don't know for sure. I think they do. I do, as a matter of fact, I happen to think that the sole focus on intellectual property as a barrier to access to these vaccines was a red herring, was meant to divert the world's attention from the real reasons why there has been vaccine inequality around the world. It is true that at least in the early phases of the pandemic, when the vaccines first became available, they were much more readily available in the United States and Western countries than in the developing world. No question about that. And it is also true that the United States and the developed countries had and continue to have a responsibility to help other nations to have access. No question about that. And the politicians were responding to political pressure on that specific point. But instead of addressing the real issues, again, export controls, issues of, last mile delivery, refrigerated trucks, vaccine hesitancy from the local populations, distrust by the population in their governments, all of those issues, instead of focusing on those, they picked intellectual property to focus on, a complete red herring that had absolutely nothing to do with the problem. So, by the way, Daryl, I was saying that the waiver will have no effect well before it was implemented. But now we don't have to guess anymore. Now we know as of several months ago, the waiver at the WTO has been in place with respect to patents for COVID-19 vaccines, and not a single country to date, not one, has taken advantage of this waiver.
So what would you like to see as a concerned US citizen, as a former leader in charge of intellectual property in this country, from the US government, from the US government's partners and allies?
I would like to see the US government have its historic position on intellectual property, that intellectual property is important for innovation. Intellectual property is the currency of innovation, and it enables the transfer of that technology pursuant to the rule of law, and that intellectual property needs to be stable and respected both domestically and around the world. US administrations of both parties throughout history have stood firm on this position until this administration right now, that for the first time has agreed to a waiver of patent rights. And we need to return to the US being a leader in the world when it comes to the protection of intellectual property rights.
Well, what has changed?
That has benefited greatly both American industry and American people, as well as the rest of the world who benefit from innovation pursuant to a stable intellectual property system.
Right, and you have a civil service that's supposed to be there to establish continuity between the different administrations. You have, as you say, a bipartisan appreciation of intellectual property rights. So what has changed with this administration that they seem to have lost sight of the ball?
Well, I don't know, Daryl, I'm not in this administration, but they have lost sight of this particular issue. Now, to be fair, the pandemic is a historic event, to some extent unprecedented in modern times, both in its scale and effect on people around the world, and they're responding to that. And on top of that, they are responding to a legitimate worldwide need of access to life-saving technologies. However, I do believe they lost track of the real issues and the importance of protecting IP, and I think they need to come to an understanding that protecting IP is the way to enable the creation of these technologies and the transfer of these technologies pursuant to the rule of law. You waive IP, you have the exact opposite effect. And
you just came back. Go ahead.
And I'm concerned that that they have lost track of that, but I think it could be recovered.
So you just came back from Israel, and you were part of 2 fireside chats, IP in the AI era, and the provocative question, is Elon Musk right, and other hot topics, patent policy issues, and he said, of course, patents are for the weak. Now, how is Israel doing, first of all, on these same issues that we just talked about? And second of all, what were your takeaways from those 2 fireside chats?
Well, it was a great trip in Israel. It was a fantastic conference. It's called the BPIP conference, Best Practices in Intellectual Property. It brings together IP practitioners and leaders from around the world to Israel for the event. Israel is a leader when it comes to technology development, is very high up in the world rankings when it comes to innovation per capita. They have an excellent intellectual property regime, and the IP bar over there, together with the innovation ecosystem, is, in my view, one of the best in the world. They are thought leaders when it comes to the technologies of the future. whether it's AI, biotech, and the like.
So when you look at how they have managed their innovation policy, are they ahead of the United States? Are there things that the United States should learn from them?
Oh, I don't know if they're ahead of the United States. By and large, I continue to believe that the US intellectual property system is the gold standard. Again, nothing is perfect. There's always room for improvement. And I'm sure we're going to get into this, but we can still do better in the US on patentable subject matter like Section 101 and dealing with multiple bites at the apple at the PTAB and injunctions and whatnot. But every country has its own issues. On balance, though, we have the oldest intellectual property system in the modern era, and I still believe that we are worldwide leaders when it comes to it. But turning to the second part of your question, Daryl, which was takeaways from some of the fireside chats I had. One of them was a fireside chat with my good friend and predecessor, Dave Kapos, where we discussed Elon Musk's provocative statement that patents are for the weak. And I said that, to a large extent, Elon Musk is right. The truth of the matter is that, first of all, obviously, everybody benefits from a good, robust intellectual property system, the big, the small, the strong, the weak, etc. But the ones who benefit most from a robust intellectual property system are the startups, the small and medium enterprises, the disruptive innovators that have to go head-to-head and compete with the large established giants. And they cannot outcompete them based on sheer market size and market power and the like. And they need the protections of the intellectual property system to be able to take on these giants. And I'm sure that's not what Musk had in mind when he said it. He meant it as a pejorative. But look, to a large extent, the fact of the matter is, on balance, the startup, the disruptor, is the one who benefits most. And I gave the example of David v. Goliath in the fight in David v. Goliath, especially because I was in Israel. And I said that, David needed a slingshot to be able to fight Goliath. And Goliath, being a giant and being able to depend on his own size, he doesn't like slingshots. He would like to, get rid of all slingshots, make them illegal, in fact. That would be better for him. But David needs the slingshot, and if he has a reliable slingshot, he can take on the giant. And to some extent, that's true for the patent system as well.
And let's talk about the other fireside chat too, since, as you mentioned, Israel is the hub of AI innovation, and so is the United States. In the last few months, you've seen everything from ChatGPT 4 now to AI that produces works that raises a lot of questions about infringement of intellectual property rights. What rises to the top of your mind when you think about AI and IP?
Well, at a high level, Daryl, I'm very concerned that the technology is far outpacing the policy in the United States, at least. And there is no robust policy or even a conversation really going on yet as to intellectual property aspects of AI. So is just the tip of the iceberg here is, should AI generated innovation be eligible for a patent? There's been a test case that's being pushed both in the United States and overseas by a machine called DABUS. In the United States, the current law is pretty clear that the inventor has to be a human being, and therefore a machine cannot qualify. as an inventor and therefore cannot get a patent. And, you know, the Patent Office concluded that that's the case based on current law. The Federal Circuit recently affirmed that. We'll see if the Supreme Court says something different. I frankly doubt it, but we'll see. But here's the bottom line. We have these technologies now. They're improving themselves very quickly. And we don't know as a country, we haven't had the conversation, what's in the best interest of the country? To have a patent protection or some form of IP protection for these AI-generated innovations or not? The status quo is not, but is that the right? Nobody has had the conversation. I'm very worried that that we're being caught off guard here without having a thoughtful national debate on these issues. And that's just the tip of the iceberg. There are questions, as you've indicated, of infringement, you know, of just basically the AI machines, you know, learning from, you know, from existing technologies and then creating something new based on those. Questions of fair use on the copyright side. There's questions of in the patent world. There are questions of disclosure. Well, what kind of disclosure do we need to have? How do you teach one of skill in the art? Who is one of skill in the art? You know, and how do you teach them to make something without undue experimentation?
So talk about those conversations a bit more, because when you were a director, you actually had a series of invitation for comments. The current director has as well. You see conversations about it at conferences all around the country, and you see conversations about it on the Hill. So clearly some form of these conversations are taking place, but the point that you make, I think, is still missing, which is a national strategy for IP. So who should be leading this national strategy for IP?
Well, the conversations are taking place, but it's you know, I mean, you and I are talking about it right now, and we're talking about it at various conferences. You're right, but I don't see much official action. Yeah, I foresaw this issue years ago when I was in the office, and we did issue the request for comments back then. But that's 4 years ago now, Daryl. The current director is, as far as I understand, also asking or going to ask questions in this area. In terms of who should lead the conversation, I happen to believe that the natural leader on all IP-related policy issues is the USPTO. It can initiate the conversations. It can organize the discussions. It can provide the data. Nobody has access to more IP-related data in the United States than the USPTO. It has the knowledge, the expertise, both technical through its examining core, as well as legal and a global policy perspective. Now, ultimately, though, the laws need to be made and changed by Congress, and Congress needs to say, that's what legislators are meant to do, debate the issue, get the information, and perhaps that should come from the USPTO, but ultimately Congress needs to sit down and debate and formulate policies. I'll give you another example, Daryl, really important. If a traditional patent is not what is required here or in the best interests here for AI-generated innovation, do we need to have a new type of IP, a sui generis type of IP, of different coverage, different duration? You know, in the drug space, for example, we have data protection, 5 years for small molecules, 12 years in the United States for large molecules. You know, that's a sui generis type of IP for those types of products. Do we need something that's also sui generis in the AI world? Those are very complicated questions. Somebody needs to start having those discussions. One more example, data protection itself. That's currently not subject to patent or copyright protection. Right now, the only protection on these massive data sets that these AI type companies have is trade secret. And, that is detrimental. It's detrimental, especially in the United States, where we have a free market economy. We don't have a centralized government, as in China, that can dictate to its various entities to collaborate, do whatever. Here, if companies retreat into trade secrets, you remove collaboration or reduce collaboration and public access. So we need to think nationally about an IP regime for data. It goes hand in hand with an IP regime for AI, but nevertheless, it's its own issue that needs to be addressed as well.
Very interesting, and I hope to be able to say you heard it here first to our viewers. Now, you talked about the need for cabinet level position for American innovation. You say that can take many different forms. It's such a critical component for our national economy and security. It needs to be a cabinet level position. Within that, there should be a whole of government approach on strategizing all of these issues. We have the IPAC, the IP Enforcement Coordinator. Is that not enough? And if not, why is it not enough?
No, it's not enough. It's far from enough. It's not at all the position that you are referencing. First of all, just as an aside, the Biden administration, we're 2 years into it and has not yet appointed anyone to the IPAC position. And it's been vacant. Second of all, it's an enforcement position. It's focused solely on enforcement, not the policies of IP, not the procurement of IP, etc. And third of all, it's a coordination position. It's not even the enforcement arm. It's just the coordination of the various enforcement mechanisms around government. I'm a supporter of that position, but it's got its own function. And I really hope the president would appoint somebody there, but it's not the type of thing that I have in mind when I say that we need a cabinet level position. We need a cabinet level position, not just for IP. We need a cabinet level position for innovation. We need a secretary of innovation, Daryl. And it is, the American economy right now, we're no longer an agricultural based economy, for example, as we were a couple hundred years ago. To a large extent, we're not even a manufacturing based economy anymore. Obviously, we do all those things. The agricultural sector is really important to the US economy. Manufacturing is really important to the US economy, and we should do a lot more of both, no question. But as to the driver of the US economy now and for the past few decades has been intellectual assets. Innovation is such an important part of our economy. It's a driver of our economic growth, of our national security, and of our well-being. It needs to have the full attention of the administration.
I find there's a bit of an irony there, given that you were a Republican nominee and Republicans are typically known for small government. What you seem to be advocating here is more government. Maybe well for good reason, but how would you convince folks from the Republican Party that more government in this case can be trusted?
Look, I don't know that this is more government. I also want to emphasize IP and innovation. These are not partisan issues. They are not traditional. The divides are not along traditional ideological lines. It's not like Democrats and Republicans align along party lines on these issues, or liberals versus conservatives. That's not how the alignments are on these IP and innovation issues. Now, on the specific thing, I actually don't happen to think that would be an expansion of government. It would be just a reorganization a little bit. All these functions are performed in various different places around the administration. All I am saying is collect them, and most importantly, is elevate it to the president's cabinet, put it in on the front line. The issues are happening, right? IP, obviously, for example, the USPTO exists. Obviously, it's happening and it's doing a very good job. All I'm saying is collect these issues and put them in the president's ear, because it is one of the most important issues for the US economy and American national security.
Share with us your thoughts on.
I want to emphasize that Daryl, that this is more than IP. IP is just one tool for innovation. This is a whole government and all policy innovation approach, which IP would be just a component.
Share with us your thoughts on the recent House hearings on IP. Do you think they asked the right questions, and were you satisfied with the answers that you heard? This was, of course, focused primarily on China.
Yeah, there was one hearing, as far as I know, in this Congress on China and IP in the House. Yeah, look, I thought it was a fine hearing. I think many asked the right questions. And it's good to have opened that conversation. And kudos to Chairman Issa for organizing that early in this Congress and holding those that hearing. I thought questions on both sides were good, and witnesses provided important testimony. The fact of the matter is that we are in an innovation race. We have been for a few years, obviously. We continue to be. It's increasing as between the United States and China. We are competing for technological superiority in the next technological revolution, whether it's AI, 5G, 6G, telecom and beyond, quantum computing, autonomous vehicles, biotechnology, advanced materials. It's a huge race between the United States and its trade partners and China and on all these fronts. So having Congress attending to that, I think it's fantastic.
Are you optimistic that they will kill this Federal Trade Commission effort to ban non-competes? You make a case that it's important to have these non-competes because they're a way to prevent the theft of trade secrets, and a blanket ban on all non-competes, as it seems California has done, would be shooting ourselves in the foot.
Yeah, so just to back up for 1 second, what you're referencing is a recent proposal by the Federal Trade Commission to ban all non-compete agreements in the United States writ large. And I and others have written on this, expressing very significant concern that if it's implemented as proposed and as broadly as proposed, it would have a dramatically negative effect on the United States and the innovation ecosystem here, and in particular, the protection of trade secrets and our ability to protect those and therefore compete as we need to with China and others. Am I optimistic that the FTC is going to drop it? No, I'm not at all optimistic that it's going to drop it. Now, what I'm hoping at least is that they're going to dramatically narrow it. There's no question that non-competes can be abused, right? And that some companies try to impose them even on their lowest level employees. And to some extent, that's not necessary.
Is it possible to draw the line? You think you give an example in your op-ed of 2 case studies, Jimmy John's, where it was improperly used, and Keurig Dr. Pepper, where it was effectively used. These are anecdotal in a sense, and it's clear that one is more appropriate than the other. But if you're going to have a rule across the board, is it possible to say this is where you draw the line on non-competes?
Look, I think it's difficult to draw the line, especially at the federal level. As far as I'm concerned, I would leave this to the states, and they've shown that they're perfectly capable of handling this issue, and they can have this debate at the state level. Now, what each state does, it's up to them. I think it's difficult to draw that line sometimes even at the state level.
Well, do you think California got it right?
I'm not an expert in exactly where to draw that particular line. As a general principle, I do think that companies having the ability to implement non-compete agreements for decision makers, for people that are involved at the front edges of innovation and technological development, I think it's important to maintain that in order to encourage innovation and the ability to freely invent and allow people to collaborate within a company without the fear that those technologies might leak. Where exactly you draw the line, though, where each state will draw the line, and how exactly they do it through legislative language, that is up to them.
So let's talk about rulemaking in another context, and that's the USPTO and the Fintive rule. On hindsight, would you have done it differently? Would you have had a notice and comment period?
Well, I think we did it the right way. I think the Fintive rule, which is not by itself, it comes together with the Sotera wireless case as well. It's under the current legislative statute is the correct policy approach. In other words, the petitioner should have the choice of filing an IPR if it wants, or of fighting in court if it wants, but should not have two bites at the apple. And the statute left it up to the director's discretion to create policies to strike the appropriate balance. And I think it's the appropriate balance. Now, I will say that it would be good for the legislature to make it clear through statutory pronouncement that there should be only one bite at the validity apple when it comes to somebody who's challenging a particular patent. Now, should we have done notice and comment? Yes, eventually. But doing, using precedential decisions is perfectly appropriate for agency action in circumstances like this, as far as I know. Otherwise, the agency is frozen. You can't have a system where an agency cannot communicate to its employees how a uniform approach to a particular administrative action if every single time you have to wait for notice and comment, because in the meantime these take a long time. In the meantime, you have an agency to run, and if you don't have this rule, if you're not allowed to have precedential decisions or some other form of communicating a uniform approach, what that means is that some employees at the office will rule one way, and other employees will rule a completely different way on the same problem. That's not good for the public. If you can consolidate and have one agency approach, as opposed to all these completely ad hoc approaches, that is much better. Now, long-term, notice and comment is a good thing. And by the way, we did start the process of notice and comment when I was there in 2020, but then we ran out of time in the administration.
Thanks.
And as far as I know, the current director, who's been in the position for about a year, still there's no notice and comment. The rulemaking package that I have seen come out, however, she has said publicly that the office is working on that. So let's see what comes out. But you can see that these things take a long time. And what are we supposed to do? In all these years, what are we supposed to do? We have 270 some judges at the PTAB. What are we supposed to do? Each one decides on their own how to handle this exact issue. So some judges will deny institution if there is a pending district court case, and other judges allow, under the same exact circumstances, institution when there's a pending district court case. All these years, the public doesn't have a way to predict how the office is going to approach. It's going to depend on which of the 270 judges you get. I don't think that's in the national interest or the wise administration of the patent system.
And thank you for sharing that. I think that's a missing piece of the narrative in the Fintive debate. So you've added some balance to that conversation. You also try to do that through your op-eds, and you spend a lot of time, you and Dave Kapos and Judge Michelle. What is your thinking behind these op-eds, and how do you measure the impact and effectiveness of these op-eds?
Look, I think it's important. So intellectual property issues are complex, nuanced. Most people in the general public are not aware of these issues, that they even exist, and then also what the nuances mean. And I think it is important to educate the public and policymakers as much as we can on these issues. Otherwise, you're left to, either a lack of knowledge, and that can lead to bad policy, or a misunderstanding, which is even worse, and lead to even worse results for the nation. So our idea is to, as much as we can on these issues, educate the public and policymakers. And you might have seen, Daryl, that we're striving to go beyond just mere intellectual property news media. We do publish in IP media as well, but over the past year or so, we began to publish much more broadly. And we publish in places such as Real Clear Policy, The Hill. We've published a big piece in Deseret News, which is a major publication in the Western Mountain region of the United States. We've published in the New York Post, I believe in Newsweek, in Stat, which is a life sciences publication. And these are just some examples. And hopefully the general public and policymakers will read at least some of these things.
Well, I think you're certainly reaching as broad a base as you can, which is the impetus for C4IP as well. So speak a little bit about C4IP and where are things right now with C4IP?
Yeah, so C4IP is the Council for Innovation Promotion that I started with Dave Kapos about 6 months ago. It's a bipartisan organization that focuses on educating the public and policymakers about the importance of intellectual property to the innovation ecosystem. We want to make it clear to everyone that a strong innovation economy is inextricably linked to a strong intellectual property system. It's very hard to say that you are pro-innovation if you are not also pro-IP. And we want to make sure that that inextricable link is clear in policymakers' minds. We've established this organization about 6 months ago to drive those points. And we do a lot of publication, as you have mentioned, Daryl, on these issues. We've submitted comments to various government agencies. Just this week, our executive director, Frank Collin, testified at the ITC on a TRIPS waiver related issue. So that's the main goal of the organization.
Thanks. Notice that we are running up on the hour. Do you have a hard stop Or can we go another 5 minutes or so?
We can go.
Okay, thanks. Because I want to talk about your personal takeaways on leadership, especially on this very auspicious occasion of your birthday coming up. So you're born in Bucharest. You earned a Bachelor of Science in Aerospace Engineering, JD from UCLA, and you have had a most extraordinary life and career. Talk to us about your takeaways on what it means to be a leader.
Well, thanks for the question. Look, one of the most formative things in my life has been immigrating to this country. I'm born in Romania. I was born and raised there during communism, and came to the United States in 1981 when I was 12 years old. And, that has been transformational in my life. It gives me a great appreciation for this country, for the freedoms and the constitutional framework of this nation. I don't take any of that for granted. I've lived and I know what it is not to have, the freedoms guaranteed by our Constitution that we enjoy here in the United States. I also know, what it takes to start with nothing, not even speaking the language, much less any resources, and making it through, and with the incredible generosity of spirit of people in the United States. So all of that has had a great impact on me and pretty much everything I have done. And I think, if you talk about leadership, I think it's important to utilize what you have learned throughout your life and try to help others, in small groups, large groups, as much as you can, achieve the American dream to the extent possible.
Do you look at China and say, I came from Romania. I know what it's like to live under a regime that is not like the United States. And therefore, I worry if China is ascendant because I do not want others to experience what I saw and experienced. How much of what you went through in the past is informing your view on where things are right now?
Yeah, look, I am concerned by the competitive nature as between the United States and our system of government and life here versus the centralized dictatorship that exists in China. Now, I'm not an expert in Chinese politics by any stretch. I don't know, and I don't want to suggest that China right now is the way Romania was, for example, during the Soviet times in the 1980s. All I can say is I'm focusing my efforts internally at the United States. I want to make sure that we compete. I want to make sure that our system prevails and succeeds, and that we continue to have technological leadership. So all of my efforts are to strengthen the U.S. innovation economy. If we want to outcompete China, we need to out-innovate China. And I want to make sure we have the right policies in place to enable our people to do just that.
Who would you say are your mentors growing up in your career as well? And who would you say are your mentees? Folks from the next generation who you hope will institutionalize some of the values that you just described?
Well, look, in terms of mentors, I will start with my parents, which saw a long time before we left communist Romania that totalitarian regimes don't work. My father had long been opposed to the communist system and wanted to get out and come to the United States. I learned a lot. From that. And I've had mentors throughout my career. I had mentors when I was an engineer at Hughes Aircraft, and in my legal career, I've always had mentors along the way. Probably the most important mentor in my legal career as a lawyer has been my partner, Morgan Chu. And once I got to government, I looked at my predecessors and tried to learn as much as I could from them. Dave Kapos is a very good example of that, but not just him. Also, my very good friend now, who has recently passed, unfortunately, Q. Todd Dickinson, who was director of the USPTO during President Clinton's time. My immediate predecessor, Michelle Lee, and I've tried to learn from all of them as much as I could. Now I'm back in private practice. I'm serving clients for most of my waking hours, but I'm also doing some of this policy work as well. I like to work with as many young folks as possible and carry this message. We need to grow the IP and innovation ecosystem with more advocates as much as possible. And you and I talk a lot about these things. And at your behest, we've often get together with folks like Judge Michel, for example, and younger folks like Brad Watts, for example. A lot of folks who across generations, but who care about these issues, and we talk about these issues, try to enable each other. And we just need to grow these groups as much as we can. And the only way to do that is through education and leadership.
Thank you. Final question. What's next for Andrei Iancu?
Well, right now my hands are more than full. As I said, most of the time I am serving clients in the intellectual property system that have patent-related issues, trademark and other IP-related issues. I spend also time with the new C4IP organization. I also spend time at the think tank CSIS, where we started the Renewing American Innovation Project from a more an academic perspective. So I think, Daryl, that's enough for now. And I'm really hoping that that we can communicate as much as possible to everyone who's involved, the decision makers in government, in industry, the critical importance of intellectual property to innovation, creativity, and just growth of the American economy and the American way of life. To me, that is the policy goal for the near and medium term.
Thank you. And what a legacy that would be to benefit generations and generations of people, not just here, but around the world. So I speak on behalf of our viewers and wishing you a very happy birthday and many more to come. Thank you for joining us today.
Thank you very much. Pleasure to be with you.